Right, Lordship. May it please your Lordship. Lordship, a bail application was filed before this honorable court. In that bail application, before the name of the accused petitioner's father, inadvertently the word late was inserted. Because of which, when the interim relief was granted to the accused petitioner, in the order also the same late word was reflected. Your Lordship, we have filed an IA to rectify that mistake. So I pray that let the matter come as unlisted before the lunch break, Your Lordship, because next 3 days it's holiday in the court. So, Your Lordship, the urgency of the matter is
Tomorrow or today?
today, Your Lordship.
Today? You'll have to mention before the senior bench. You hurry, otherwise it will be too late.
Yeah. May it please your Lordship, with the consent of other side, I beg to mention item number 13, Lordship. Item number 13.
My lord, this is a very old pending matter. My lord, the council informed that he has some eye problem. My lord, that is why I consider otherwise they have taken time very as well. It's 2013 matter. So it may fix on 23rd, my lord.
23rd
23rd.
September? Not on 23rd September, last week.
Yeah.
We have motion week only.
Then my lord, it will be after 14th of October, please.
Yes, fine, 14th of October. Learned Counsel, Mr.
A. Singh, Lordship.
A. Singh on behalf of Learned Counsel, Mr.
R.K. Bhuya, Lordship, appellant.
R.K. Bhuya, representing the appellant, has prayed for adjournment as Mr. R.K. Bhuya is suffering from eye
Problem.
To some learned senior counsel, Mr. G.N. Sahara has submitted that several adjournments have been taken. And a last opportunity may be allowed.
My lord,
And a last opportunity
Last-
may be allowed. Full stop. A last opportunity is accorded. List the matter on 14th October for hearing positively without fail,
Obliged.
as this is an old pending matter. Item 1.
Look, this is another bail application on behalf of the petitioner who is behind bars since last 2 years, 3 months in connection with this case, and all co-accused have been.
Call for the trial court.
Scan
records.
copy of the TCO.
Call for the scan copies of the trial court records along with the scan copies of the CD list, entire CD list, the matter on 18 September.
Otherwise.
Item number 2. Item 2. Is there any element of settlement?
My lord, actually, last 10 years, this case is pending, and in this honorable court, 4 occasions they appeared, but husband is adamant, the appellants. So I think there should be.
There has been like mediation.
Okay.
he's coming just now.
3 to 6, no?
3 to 6 now.
Item number 7 for bail hearing. NCB, yes.
Yes, Lordship. Lordship, NCR not received, Lordship.
We'll need the LCR. LCR as called for is not received. Issue reminder, TCR, huh? Issue reminder to forward the scan copies of the TCR along with the scan copies of the CD list. 19 September.
But
Obliged, Lordship.
Item number 8.
Lordship, may I please, Lordship? Item number 8 and 9, Mr. P.S. Locker will appear, Lordship. This two matters may be possible for the timing.
For the time being.
today, my lord,
132 days, madam.
For the time being.
Time being,
Time.
Mr. P.S. Locker will appear. সেইটো তোমাৰ গম নাপাওঁ, আমি বেলেগ কোৰ্টত দিছো। Time being কৰি আপুনি নকক ফোন কৰিছে আপুনি ফোন কৰি দিব
10 to time being, oh, acha, sorry.
May it please your Lordship. If the second appeal, Lordship, was admitted In the second appeal, Lordship, the appeal was admitted and substantial question of law has been framed regarding maintainability of the suit. Our prayer was that the issue number 2 that has been decided by both the trial court and the first appellate court after reappreciation of evidence, the issue number 2 regarding maintainability of suit was not decided properly or reappreciated. So this honorable court, for Lordship kindly peruses, has been one substantial question of law regarding non-impleading or
no,
joint
wrong
of a
submission.
necessary party.
It is wrong submission, Lordship. Kindly see last order, Lordship. Limitation.
Now,
file-
may I submit one thing, Your Lordship? The
Still it
objection
is not
that has been
substitute
filed.
the,
This is not a substitution petition. I am pressing the ISC bill number 1610/2024. And that is regarding ISC bill 820 of 2025 that has been filed and no formal notice upon the legal error still to date has been issued by this honorable
still
court.
party is not informed, Lordship. Kindly see, Lordship.
ISC bill was filed for substitution of the legal heirs of deceased respondent number 5. In the meantime, the learned counsel appearing for respondent number 1 and 4, they have filed their objection. And others in the IN number 820 of 2024-25. But regarding the stay of the impugned judgment and decree that has been pending since 2024, because we have filed an additional affidavit where we have, may I submit first, Your Lordship? Because being the appellant, I have my prerogative. The execution case, next date is fixed on 17/9.
Without complete the formality, how can continue this case, Lordship? I not think.
Prima facie
Still,
execution.
respondent number 5 is not included. How can he go to the stay order and also another thing?
Because after notice has been
At first,
issued,
At first you complete the procedure, then you can go.
then
We
in
will
that,
come in a chronological order,
Lordship,
in chronological order.
in that case, on 17/9, the date has been fixed. So some protection may be given on say up to
No,
that
no,
date.
no.
No.
820, Lordship, kindly see. His file.
RSA was filed at the time of filing of the RSA, Your Lordship.
Hmm.
And when the RSA we have prayed for, notice was issued,
After 886 days, Lordship, she can come with it.
that
In
then
first
that
appeal, he
legal
also not
legal
substitute.
errors were not.
Also, second appeal not substitute. How can he continue, Lordship? Also, it is a concurrent findings in trial court, also affiliate court.
Admitted the appeal based on maintainability of the suit, Your Lordship. The NHAI was not made party, the government was not made party in the suit, and that was not appreciated by the first appellate court also. So on one substantial question of law, the second appeal was admitted. Be that as it may, IA
This is
was,
for compensation.
yes, Your Lordship, based
So
on
there is
our,
no hurry. Where is the hurry?
because execution case is pending, Your
What
Lordship.
kind of execution case?
I have filed an additional affidavit in IA 1610 that may kindly be perused, Your Lordship, on 19. This is on record, Your Lordship. Because here we are facing all these formalities, we will do my best. I will do what the procedure says, I will do that. Notice will be issued by this honorable court, we will take steps, it will take time. But on the next date is fixed on 17/9, Your Lordship.
No, Lordship, at first he can condone the 882,
In that case,
820.
legal acts of the.
Then he can
deceased
continue. I have no
are
objection.
to make parties in the.
Still party is not,
Issued in this case.
they are.
Lordship may kindly peruse,
How can he continue?
order dated.
I just want to know what kind of execution you're talking about.
820, Lordship. IA 820. After 886.
Will come later on, Your Lordship may kindly peruse
No, no,
the
no.
additional
No,
evidence
no.
we have,
I have
affidavit we
strong
have
objection,
filed
Lordship.
on 19, Your Lordship. in
After
the stay petition.
820, if court has condoned, you can proceed.
That is a different issue.
If it's not different, question.
We have filed on 19/2025 and
It is a concurrent finding, Lordship. Already.
additional affidavit. Your Lordship, we have adduced all the record of the execution case that is pending, 3 of 2017, where the next date for payment is 17/9, Your Lordship. 820 will take steps because notice was not issued upon the legal heirs. That is to be issued first, Your Lordship, on the legal heirs of the deceased respondent number 5.
No, you cannot misguide the court.
We am not misguiding the court.
You are misguiding.
I am not at all misguiding.
At first, you can come to party, then you can proceed.
Until and unless the legal heirs not.
Without
issued-
party, how can you can take?
Until and unless the legal heirs are not issued notice by this honorable court until their appearance.
If stay is provided, lordship, it is in first time in motion time, court can give him.
Court has issued notice.
Court is
on the-
no, it's very
And we
clear.
should take the party there, the legal heirs of the respondent number 1 to 4. They have not filed any objection in 1610, your lordship. May kindly.
No, I filed lordship objection
That
in
is in
820,
820,
lordship.
lordship.
Last occasion, whatever is.
I just want to know what
What is
kind
the
of
order?
execution? What kind of
Because
execution?
may I submit in this regard, your lordship?
Mm.
Suitland was. Suitland was.
Oh, you'll take over the suit land. They will take
No,
over
no,
the
your
suit land.
lordship. Suitland was taken by the NHAI
Mm,
for construction of the highway.
mm.
Based on our position, the deputy commissioner.
What type of
Our-
land? It is not, it is the allotted land, lordship. Government
Lordship,
allotted.
Submit first. I may be allowed to submit
Mm.
until and unless I complete my submission. Suit land was a ceiling surplus land. One of the legal heirs of the LOT filed a suit for right title interest and confirmation of possession. For 1 second, your lord. Right title recovery of the amount, compensation amount that has been received by the appellant, who was the defendant number 2 and the defendant number 3, who is made added as a party. Now, suit was filed for right title interest and recovery of the money that has been received by the appellant, being one of the possessor of the land. This land was basically sitting surplus land. When DC, as per procedure of NHAI Act 1956, gone for deciding the part who will get, they have found appellant on possession of the land. Based on their position, out of 2,25,000, 91,000 of the entire compensation amount were allotted to the appellant. Now, appeal, during the pendency of the first appeal, the record of the miscase, that has been filed as miscase 40 of 2010 by the respondent side, has been called for. An official witness from the DC were also examined, where they have stated that based on the fact of possession, we have been given the amount of compensation. Now, while deciding the appeal, the Honorable First Appellate Court did not decide the issue of maintainability of the suit. That was the issue number 2, where National Highway Authority was not made party. Based on that, this Honorable Court framed a substantial question of law that without making a party, the National Highway Authority, the suit, how it has been decided. May your lordship kindly peruse the order dated?
No, it's okay, it's okay.
So
That,
at this
uh,
stage,
That substitute question of
on
law has been
the
framed, yes.
on the first state, court has this honorable court was pleased to issue notice. On return, your lordship may kindly peruse the record of 1610. All the parties appeared. My learned friend was supposed to file an objection on that day.
No, 5
They
is
have
not
stated.
appear.
Lordship may kindly peruse the record.
5 is not appear.
Lordship may kindly
It's
peruse
okay,
the
it's
That's why he substitute lordship.
Now-
Okay, I'll hear both sides.
during the
please.
pendency of when notice was issued, on returning date, we have come to know that respondent number 5 during the pendency of appeal died. So we are not aware of the fact that has been stated in ISC Bill 820 of 2025. Now, in that case, while issuing notice, the legal heirs of the deceased respondent 5 were not issued with formal notice for appearance. My learned friend filed an objection where we will file our reply. But first of all, fact is that this honorable court may issue notice upon the legal heirs of the deceased respondent number 5, which was not issued on the last day. Your lordship may kindly peruse 820 of 2025, your lordship. Now, during the entire proceeding, there is an execution case pending. Execution case 3 of 2017. Now, this honorable court on the first date issued notice, and on the returnable date, my learned friend stated that he will file an objection in IU 1610 against the stay. But no objection has been filed till to date in 1610 of 2024. that we have prayed for stay of the judgment and decree of first appellate court during the pendency until disposal of the RSA. So we are pressing this matter today by, we have mentioned because the next date in execution case is pending of 17-9, where appellant has been directed to make payment of his portion with what he has received as compensation. But my submission is that during the pendency of entire process, if the execution is done, the entire merit of the RSA will go.
Okay, I understand.
That's why I am pressing until disposal of the RSA. In the ISC Bill 820, that is regarding implement of or substitution of legal errors. So this
Okay.
is respondent
Respond
number.
number 5.
Yes,
Lordship, question is that
and in that IA will file our objection, Your Lordship. I have not filed yet. The argument will be done on the next day.
question is that Lordship, the appellant Shafiqur Rahman Mazhar Bhuiya is a teacher, Lordship. The land
At the second
belongs-
appeal state court.
belongs
my-
to 1 to 4, Lordship. They are allotted. Shafiqur Rahman just manage the authority and grab up the 1 lakh money, Lordship.
In that
And
case,
this-
Your Lordship
Lordship,
have to
question is
see
that
to the record
if-
where we have
but
filed our written
Then
statement.
Lordship, the court has appellated for also.
We are not even possession of the land
Yeah.
that has been allotted to the legal heir of Motosin Ali. We are on possession of a different land
Okay.
of the,
First question is that if he is the landowner, how can he got this land?
that
Lordship?
is to be decided.
No, no, no.
The law-
The
this
question is not that.
court is only after the
Let me submit.
substantial question of law, Your
Let me
Lordship.
submit.
Merit of the facts will not be.
Wait, just a moment.
Now the question is not,
No, I'll take it up. I'll take it up for hearing.
Because
It's
this
okay. It's
second
okay.
appeal
Before,
court is not
before
a
16, I'll fix a date. Next date is fixed on 16.
17, Your Lordship.
17, before 16, 17, I'll fix a date.
Yes, Your Lordship.
I'll fix a date. Both parties, you file your objection, and then I'll take this matter also.
I have, in 1610, we have a prayer for stay.
no, no, no.
The
no.
other side has
No,
not
I'll
filed
take
any
it up.
objection.
Unnecessary,
I'll
Lordship.
take it up.
Unnecessary.
No, no,
That is not at all unnecessary. Your
I'll
Lordship.
find out. I'll find out. Whether
Yeah.
necessary or unnecessary, I'll find out.
That is not at all unnecessary, Your Lordship.
No, no, no.
You
Lordship.
file your objection in both the petitions.
Because in 820
And
notice is
for,
not issued.
in one case, you'll have to issue notice, I think.
Yes, in
which one?
820 formal notice is to be issued on the
Yes,
legal errors
you
of this
issue notice
respondent
in
number
820.
5.
Before 16, I'll fix a date.
Yes, Your
And
Lordship.
that day
That
I'll
will be-
pass an order. Learned Council, Miss. S.
Not a single document they have,
It's
Lordship.
okay, it's okay.
That is a part of trial
Miss S.
record, and the
Nandhi,
second appeal
present
stage
for the-
will go by law, Your Lordship.
Not, no.
Section 100 is
You are
very
for the
much.
appellants, no?
Yes.
Concurrent finding also, it is also,
But
court has
when
allowed.
the issue of maintainability of suit,
Court
this
dismiss
honor-
this appeal, Lordship.
this honorable court
Hmm.
fit the substantial question of law.
Now
Your
the
Lordship.
question is also, after
That
886,
is
they also filed.
the
this.
hearing,
Which
Your Lordship.
petition have you filed? Which IA have you filed?
Lordship.
Which IA have you filed?
Lordship, 820, Lordship.
1610, there is no objection.
820, Lordship, it is also still,
Only
mane, it is under the limitation act.
Only 820 you
Only
have filed.
820, Your Lordship.
820. 820, 2025. Limitation act, Lordship.
In this case, I will file my objection, but
आज
I,
केड़ा है pending है sir? केड़ा है pending है sir जी?
820, Lordship. I file objection, Lordship.
Okay, okay.
we are
Okay.
not, at this stage, notice will.
See,
go in.
okay, huh? 1610 you have filed.
Yes, Your Lord, for stay of the impugned
And
judgment.
3192?
Even- T192, also I filed.
So they have filed that if the 50% of the decretal amount is paid before this honorable, as if Your Lordship passes an order,
Hmm.
No, I won't pass an order here, 3192. Then 3192 no laba, huh? 1610 laba, RSA laba, 3192 no laba. মই ক্ৰছ কৰি থৈ দিছো ইয়াত তাৰপিছত 3583
Yes.
that is a substitution regarding Lordship, order 22, rule 2.
okay
Substitution of the legal errors, this is respondent number 5.
One time they are
that will
substitute,
come later.
another.
They'll come later after condemnation.
Yes, Your Lordship. And in IA
3583 লিখি দিবা 3583
820 Lordship, notice will go up.
820 who has filed
They
820
also want this.
and 819
That is Lord setting aside abatement, Your Lordship.
okay লিখা learned council miss এটো IA 1610 RSA তাৰপিছতে 3583 819 আৰু 820 Ms. S. Gupta is present for the, Ms. S. Das Gupta is present for the applicants, stroke applicants, and learned counsel, Mr. A. H. Alamgir is present for respondent number 124. Applicant, stroke applicant to take steps to issue notices to, so respondents, okay? All the respondents to issue notices to the respondents.
No, Lordship, it will
One to
shoot
four.
on the legal layers upon the legal layers of the deceased respondent fiber. Rest are appearing, Your Lordship. In 820.
In 820.
Yes, Your Lordship.
Legal layers of the 820 লিখে দিয়া 820 বুলি
We'll take steps upon the legal layer.
to issue applicant to take steps to issue notice on the respondents of stroke opposite parties of respondent number 5.
This is respondent number 5.
List the matter on 16th আগত দি দিও 11 September.
11.
I'll pass an order that day relating to
okay.
everything. And then any objection has to be filed, and please file the objections on all the petitions.
Because I have nothing to file in one.
Okay, then he will file.
Yes, Your Lord.
এই এইটো আজি দি দিবা দেই মোৰ লগত অৰ্ডাৰৰ কাৰণে দি দিবা এই এখন কজ লিষ্টখন দি দিবা অৰ্ডাৰবোৰ চেক কৰি চাব লাগিব তুমি ৰেকৰ্ডৰ লগত অৰ্ডাৰখিনি দিবা দেই
May the Lordship. Lordship, this appeal is preferred by the insurance company, Lordship. Because the insurance company proved that the offending vehicle driver did not have a valid driving license. However, the learned member applied the principle of pay and recovery, and as your Lordship knows that as per the new act, there is no provision of pay and recovery. That is the main ground you are taking for the appeal. And other grounds regarding quantum, Lordship.
Lordship, this is an injury case and 50% may kindly be allowed to deposit pending disposal office and claimant may kindly be allowed to withdraw. Injury case is a small amount, Lords.
So for withdrawal, they can file a IL, Lordship, because there is a pay and recovery order.
Long pending, Lordship. Last
I
time,
have-
file an I please file
I
an
have no objection in depositing 50%.
file an I learned counsel Mr.
SP
SP
Sharma.
Sharma is present for the insurer and learned counsel Mr. A.
PR Agarwal.
These cases are all together, no?
No, Lords.
No, Lordship.
Different, only 3.
Only 3, okay.
Last
Call item
one is
number
on
3, huh?
15th.
A.R. Agarwal is present for respondent number 1. Full stop. The insurer is aggrieved by the judgment and order dated 6/2/2025 passed by the learned member MSCT in MSCT Kamrup M in MSC case number 211 of 2019, 211 of 2019. Full stop. It is submitted that, what was your submission?
Lordship, the insurance company proved that the driver of the offending vehicle did not have a valid driving
It
license.
is submitted that the insurance company could prove that the driver of the offending vehicle did not have a driving license, but the learned tribunal passed an order directing the insurance company to pay the compensation. Full stop. Admit, issue notice to the respondents. Number who will
It's
be
the number 2 only, Lordship.
respondent number
One
2,
on the deal.
returnable within 4 weeks.
have not received the
Mr.
copy.
A.R. Agarwal. It naলাগে.
Copy may kindly supplied. I have not received any.
Okay, okay. Learned counsel, Mr. A.R. Agarwal has accepted notice on behalf of
Claimant.
respondent number 1,
One claimant.
full stop. Claimants, appellants to furnish copies to the respondent number 1. I to like. Learned counsel, Mr. A.R. Sharma, no?
SP Sharma, Lordship.
SP Sharma is present for the insurer and has filed this application with prayer to stay the judgment and award dated 6/2/2025 passed by the learned member MSCT 6/2/2025 date passed by the learned member MSCT in a number 2 Kamrup Metro in MSC case number 211 of 2019. As the insurer is agreed by the judgment and award, full stop, it is submitted that the insurer could prove that the driver of the offending vehicle did not have a driving license, but the tribunal has passed an order against the insurance company to pay the compensation to the claimants, full stop. Learned Counsel Mr. A.R. Agarwal is present on behalf of the respondent number 1. Full stop. Considering the submissions at the bar, the judgment and order dated 6/2/2025 is stayed until further order, subject to the condition that the insurer deposits 50% of the awarded amount within 4 weeks from today before the registry of this court.
Yes.
In terms of the above observation, I stands disposed of.
Madam.
Item 4.
Lordship, here the offending vehicle driver was a minor and he did not possess any driving license. But the learned member applied the principle of pay inequity.
Issue notice?
Yes.
Issue notice. I'll admit the appeal.
Yes, and 50% Lordship, but no withdrawal. It is a stay,
Pay and recovery.
pay inequity. 50% we are ready to deposit, but no withdrawal. Lordship.
I do Lifadun, Learned Counsel Mr. S.R. Sharma is present for the insurance company and has filed his application. Full stop. The insurer is agreed by the judgment and award dated 9/12/2024 passed by the learned member MACT in MACT Bongaigaon in MAC case number 157 of 2017. It is submitted that the offending vehicle was driven by a minor, but the learned member MACT has passed an order for pay and recovery against the insurer. Full stop. It appears that the impugned judgment and order may be stayed. Full stop. Thereby, the judgment and award dated 19/12/2024 passed by the learned member MACT Bongaigaon in MSC case number 157 of 2017 is stayed until further order, subject to the condition that the insurer deposits rupees or 50% of the awarded amount before the registry of this court within 4 weeks from today. Post of meanwhile, issue it dispose of no. Meanwhile, issue notice to the respondents. To all the respondents, stroke opposite parties returnable within 4 weeks. Post stop. Etu he agorkhini paragraph likhi diba. Learned Counsel Mr. S.R. Sharma is present for the insurer, agreed by the judgment and order dated as driven by the minor. Ekhini di bhai diba. Admit likhi diba. Admit. Issue notice to the respondents returnable within 4 weeks. Call for the trial court records. List accordingly.
Pending item 5. Lordship, here the offending vehicle did not have a route permit, Lordship. Learned member applied pay inequity. So similar order.
Similar order.
Yes. And in the stay, Lordship, we are ready to deposit 50%.
I Likija, Learned Counsel Mr. S.R. Sharma is present on behalf of the applicant. SP Sharma, no?
Yes.
SP Sharma is present on behalf of the applicant, insurance, for my insurance company. Full stop. The insurer is agreed by the judgment and order dated 23/10/2024 passed by the learned member MACT. Number 2, Kamrup Metro in connection with MSC case number 596 of 2019. The insurer is agreed by the judgment and order as the driver of the vehicle was a minor.
No, Lordship. Here the vehicle did not have a valid route permit.
Or as the vehicle did not possess a valid route permit, but the learned tribunal has directed the insurer to pay. Learned tribunal has passed an order for pay and recovery against the insurer. Full stop. It appears that the judgment and order, operation of the judgment and order may be stayed, thereby the impugned judgment and order, operation of the, thereby the operation of the impugned judgment and order dated, award date, modern high award. Award dated 23/10/2025 in connection with MSC case number 596 of 2019 is stayed until further order, subject to the condition that the insurer deposits 50% of the awarded amount before the registry of this court within 4 weeks from today. It will dispose no. Meanwhile, issue notice to the respondents returnable within 4 weeks. তাৰপিছতে MSc কেছটো MSc এপিলটোত লিখিবা একেখিনিয়ে লিখি দিবা পে এণ্ড ৰিকভাৰী pass an order for pay and recovery admit লিখিবা তাৰপিছত admit লিখি দিবা issue notice to the respondents returnable within 4 weeks meanwhile call for the trial court records list accordingly list accordingly দুইটাতে লিখিবা dispose কৰা নাই
Item 6, Lordship, here the driver did not have a genuine driving license. The
Okay.
driving license was fake.
fake driving license Learned counsel Mr. SP Sharma is present for the insurer IA to লিখিবা
50%.
comma who is aggrieved by the judgment and order dated Three 2024 passed by the learned member MSCT number 2 Kamrup Metro in connection with MSC case number 798 of 2018 full stop. The insurer is agreed by the judgment as the driver of the offending vehicle was in possession of a fake driving license, but the order was passed against the insurer to pay the compensation amount. Full stop. Considering the submissions, the operation of the impugned judgment and award dated 3/12/2024 is stayed until further order subject to the condition that the insurer deposit 50% of the awarded amount before the registry of this court within 4 weeks from today. Meanwhile, issue notice to the respondents returnable within 4 weeks from today, list accordingly. আগৰটো সেই তেনেকে লিখি দিবা গোটেই ষ্টৰিটো এডমিট লিখি দিবা নাই পাৰ্টি আহা নাই এইটো পাৰ্টি আহা নাই
Deeply obliged.
আৰু ট্ৰায়েল কোৰ্ট ৰেকৰ্ড কল কৰি দিবা মানে যোনটো MSc এপিল আছে ট্ৰায়েল কোৰ্ট ৰেকৰ্ড
Obliged.
You have the CD?
Say LCA come. TCR come.
Zero.
Allegation is against the petitioner is Pakistan Zindabad.
Okay.
That is the only mention. From the Facebook account of the petitioner, my lord, someone sent the notice. And as on today, my lord, 132 days my lord, he is in jail.
100
132 days.
is facing trial?
Trial is started, my lord. He is in jail, my lord.
Well, it is not, evidences are not started yet. Also. Just leave it.
All right. Yes. Hope it does not exceed more than this. I'll give certain conditions then. But your objection will be
That's it.
recorded.
Good point.
Third learned counsel Mr. S. Islam for the petitioner, Nazrul Islam, who
S.
has,
Islam.
who has filed his application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since
26/4/2025.
26/4/2025 in connection with sessions case number sessions trial number P2/87/2025 arising out of Popiragram PS case number so and so registered under section so and so. So which what are the statutory period of all these offences?
60 days, my lord.
60 days. It is submitted that the statutory period is only 60 days, under which offences the petitioner is booked. Full stop. However, the petitioner has been behind bars for how many days?
132 days.
132 days. Full stop. It is submitted that the petitioner will cooperate with the trial and will abide by any stringent bail conditions if imposed upon him. Full stop. The learned additional PP has raised objection stating that trial is at its initial stage. Full stop. I have considered the submissions at the bar with circumspection First off, I have also considered the submission that the petitioner is willing to abide by any bail conditions, full stop. Considering all aspects, the petitioner is enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the learned trial court under the condition that the petitioner shall refrain from such activities with which he is alleged. Number two, the petitioner shall not leave the jurisdiction of the court without prior permission till completion of trial. On breach of any of the bail conditions, the trial court is at liberty to immediately cancel the bail granted to the petitioner.
Obligation.
I think I said that.
Yeah, please. City was called for in this case, and this is the third time bail
You
application.
have the CD?
We have received this in the lordship. Yeah, in this case, lordship, one person is missing, lordship, but till date he is not been recovered, lordship. And
He has
his,
not been recovered.
and his involvement are there, involvement, this person's involvement is there.
This,
lordship.
this is, AB.
AB,
AB lordship.
No.
but
Where is the FIR?
I am, yes, FIR at page 18,
No, let the
Type
person be
A.
recovered, then we will grant you bail. Page 80,
page 18, can you find?
18.
Right.
Please read.
With the due respect, I beg to inform you that my son, Messer Ali, who was employed in Delhi as laborer, has gone missing while he was coming to Kokrajhar to his home by train on 21st February 2023. After having an extensive search, we have unable to find his whereabouts, and as such, we have lodged a complaint at the local police station as well as at the Bongaigaon GRP. And search is still on, but yet to get success. As per the direction of the OC of Bongaigaon GRP, this complaint is
So
being
what do you
filed.
have in the CD?
Yeah, in the lordship, there was some love affair with this persons and the wife of the missing person. And for that person, when some earlier the wife of the person, he was out of Assam, and thereafter his wife called her, and he came, but from the station, from station itself, he was not missing. So his information is there.
So my lord, in this case, my name is not in the FIR.
What is your new ground?
New ground, I have, my lord, I have pointed out that the phone number that was in last contact with the missing person is not belong to me. It is not in my name. So in the basis of the FIR, that phone number contact is making here basis that this phone number was in contact with the victim. So that number is not belong to me. And second thing is that.
Which one? 9387272?
Yes.
But father has stated that this is his son's phone number, no?
This is son's phone number, but that phone number was in last contact with another phone number. And that phone number doesn't belong to me. It is investigation have to point out whether that phone number belongs to whom.
Let me see the CD.
And it is an admitted fact that victim was employed under this petitioner before lodging this affair many long ago, and he went to Delhi for labor. Oh, he left my job. So I had no contact, and this lab affair, it is.
It is in the CD.
It
Yes,
is.
Earlier, there was some threat from this person also.
Mention case.
Hmm?
Mention case.
Or if lordship gives some more time, some time to us lordship, then I can take instruction from the IO, because it is not actually, the CD is not clear to the entire incident. I can take instruction from the IO how how that same has come.
My lord, in this case,
Whether-
my humble submission will be that love affair angle, it has been allegedly given by the family of the victim.
Witnesses have stated, at least two have stated. So far as I'm reading, two have at least stated. And then that he has called with the help of his wife.
No.
That is there. He has disappeared, not died.
That is not
Finding,
clear.
finding has not come out.
Whether he is missing, whether he has died, nothing has come out. So that is why I'm paying for some more time, so that I can take instruction from the IO, what is the present status and how he has been, this person is connected to the entire episode.
He has fled. Because he was threatened by him, so he has fled, but he has disappeared. Maybe he's hiding or something like that.
Ultimate findings should come out whether he is alive or he may be.
Lordship, maybe visit on my 15th of September, Lordship. In the meantime, I will take proper instruction.
We'll send it back,
Well-
call for the up-to-date.
Not.
Send back the CD, call for the up-to-date CD, list the matter on 15 September.
15th.
My lord.
Yeah, please, Your Lordship. Lordship, in this case, I file a separate IA number 2933 2025 for stay. That may be come up along with the IA on Monday.
Monday?
Lordship, not Monday, we are going to file objection, at least 1 week time maybe give you.
There is.
No, no, you'll file IA, then I will come on Monday, then you file objection. Okay,
In the meantime, they can file objection. Actually, what happened, there is some urgency. That's why I'm praying for Monday. Otherwise, they started the execution and execution is on 10th of September on
then you
Wednesday.
can file, meanwhile, then we will fix on a later date, let him file the objection.
Yes.
Yes,
On Monday, maybe come up.
not Monday, maybe some other date. 5th September? No, 5th September to Kalle. No, Furuhile. 11 September, 11 September,
Before 10th, my lord.
before
Execution proceeding is on 10th,
9 September.
night September.
List this matter on 9 September.
Along with IA, my lord, IA one,
Raise
2933.
the IO filed by the appellant.
2933, 2025, IA. 2933, 2025, I number.
Yes, filed by the appellant on record. Please to place the IO filed by the appellant on record.
Lordship, if possible on 12, because we have to collect the execution, the documents of the execution, Lordship. Because
No,
execution
no.
proceedings going on. So let come.
9th, my lord. Please.
Obligation.
Okay, to. Yes, yes.
Otherwise, I have gone through the records, my lord. And here there are 6 prosecution witnesses. Only the entire case depends on PW 1 and 2. PW 1 is the victim and PW 2 is the, my lord, eyewitness, and PW 5 from the medical witness, medical officer, my lord. Otherwise, from the injury report, although case was initially search frame under section 326 and 307, well, ultimately, my lord, from the injury report, my lord, from the evidence, it reflects that injury is not grievous, and for which, my lord, and regarding 307 also, ultimately, after analyzing the entire evidence, my lord, that case does not come under section 307. So ultimately, my lord, accused person was convicted under section 324, and my lord, for sentence for 1 year, my lord. And here, my lord, vital witness is PW 1, my lord, victim, injured witness, and PW 2, eyewitness. And defense witness, in fact, my lord, supports the case of the, my lord, prosecution. That on that day, particular day, but the accused person, he went there and by way of sharp cutting weapon, my lord, he assaulted the victim in his stomach or chest, and that was witnessed by PW 2. And PW 2 and statement of PW 1 also corroborated by PW 2. And thereafter, my lord, did state from the defense witness, it reflects that on that particular day, actually he went to the place of occurrence. So, my lord, the fact that at that point of time he went there and caused injury to the accused, in fact, my lord, supports the case of the prosecution. Otherwise, my lord, from the materials and evidence of there is no illegality, my lord, Learned Trial Court rightly convicted the accused under section 324, my lord. Although, my lord, by converting section 326 as per provision of 222. Otherwise, my lord, only aspect is that conviction is for 1 year, and from the evidence, in fact, it reflects that he is the second victim.
Section 324.
Yes, 324. Okay. 324. 324. And from the evidence also, my lord, it reflects that the victim is the second wife of the, my lord, accused person. Otherwise, my lord, from the materials available on record and from the evidence clearly established that on that day, my lord, it is the accused, none other than accused, who caused injury to the victim, my lord. There is no infirmary order. Otherwise, regarding
Bail, no?
otherwise, regarding conviction of 1 year, regarding consideration of probation of that, I will leave it to your lordship. Yes. Sir.
Hard miss.
A.M. Hussain.
A.N. Hussain, legal aid counsel. You are legal aid counsel?
No, no.
Learned counsel for the appellate, and learned additional PP, Mr. P. Bothagur for the respondent, reserved for judgment and order. NCR to deal, huh? আৰু এই জাজমেণ্ট আৰ্গুমেণ্টটো পিন কৰি থৈ দিবা এইটো আধা চমিলাই কৰি দিছো পেন ড্ৰাইভ দি লৈ ল'ব হা কোনোবাই লৈ থৈ যিকোনোৱে লৈ থৈ দিলে হৈ যাব মিনিও আছে
As usual.
Yes, yes.
While the appellant is a pillion writer,
Pillion writer.
and appellant is a
Absolutely.
pillion writer. And the honorable court has directed the owner of the vehicle to pay the awarded amount. Page 19 is the judgment.
Okay.
Before coming to the judgment,
Very AC to all of sorry.
I would like to highlight the fact.
Mm.
There was a scooter. The scooter was driving by the rider. And in the backside of the scooter, there is a pillion rider is there. So a stray dog was in front of the scooter. So that meet with an accident,
Claimant or deceased? This is injury or?
injury case.
Mm.
So whatever out of the accident, the pillion rider was sustained grievous injuries.
Mm.
And he was remained in the hospital long time. Thereafter, he has filed a claim application before the learned tribunal.
Mm.
The learned tribunal, after hearing the parties, passed the award directing the owner of the vehicle to pay compensation on the ground that this is a liability policy. And the liability policy do not cover the risks of do not cover the pillion rider fine. That was the bone of contention for the learned tribunal. Now, the improved as operative part is page 21. If your lordship kindly have a look, reasons and decision thereof, page 21. Page
You are
21.
for the claimant or for the driver or for the owner?
My lord, I am for the claimant.
Claimant, okay. Page 21, yes.
Yes, page 21, operative part is page para 4.
Mm.
It has come during the trial that offending vehicle was insured with opposite party number 1.
Mm.
And the policy number so and so, and the validity of the period is so and so. That the opposite number 1 and 2 denied abatement made in the claim petition, but failed to show that at the time of incident, the driver did not have valid license or has prevented from driving the vehicle. The claimant number of PW1 exhibited document like so and so, so and so. Para 5. PW1 Krishna Chauhan claims that he is a witness of the incident from the close range. The total medical expenditure is estimated 2,65,000 so and so. From 7/11/2023 to 21/11/23, the claimant was remained as injured patient in Hayat Hospital, Guwahati. In Hayat Hospital, his injury was diagnosed head injury, brain, confusion, BL, so and so, with calibre fracture. The claimant claims to be a businessman. His monthly income is shown as rupees 7,500. It has come to his evidence that how long the claimant was away from his business. However, it is held that 3 months he was away from business profession. The claimant also did not make any effort to show his quantum of monthly income. Therefore, his monthly income is considered as rupees 3,000. So his loss of income will be rupees 9,000 per month. For non-pecuniary damage, such pain and suffering, nutrition based so and so, is rupees 3,24,688. The insurance policy was liability policy. This is the bone of contention. Since it was liability policy and the insured pillion rider is the liable. In so and so, general insurance company so and so, it was held the Honorable Apex Court, the insurance being statutory policy,
does not cover the risks of death or bodily injury of the gratuitous passenger pillion rider. The insurer is liable for compensation on the death of insurance of a pillion rider only in case of comprehensive policy. The opposite party, number 3, Kanjal Kumar Brahma, is directed to pay the aforesaid sum to the claimant with an interest of 6% per annum from the date of filing of the claim till with a period of 3 months. In default, another interest 6% will be.
Okay, yes.
This is the case. So my submission is before your lordship in my appeal memo is, my lord, if your lordship kindly have a look in page number 5 of column number 3,
Page 5.
page 5.
Yes.
The learned tribunal committed erred in law in accepting the statement of the insurance company holding the view that the policy of the act policy without bringing the same on record. This was not brought on record.
Okay.
Which is erroneous and illegal, and as such, this impugned judgment is liable to be set aside. This is my bone of contention. And my lord, the pain recovery, your lordship is very well aware, since he has sustained grievous injuries. Now the insurance company shall have to pay and recover from the owner of the vehicle. This is my submission before your lordship.
There's no order for pay and recovery. No order for pay and recovery.
No other order from pain recovery. This was not given by the court below, my lord.
Okay.
This will be decided by the affiliate court, my lord.
Okay.
When there is.
You're for the owner or for
No,
the,
no, Lordship.
for the
I-
insurer?
Yes, owner has
No,
no.
I want to point out one defect here. Maybe the owner will be burdened if I point out the defect. When the person is alive, that injury, loss of dependency is not, personal expenses is not deducted. When the person is alive, I don't think so personal expenses is deducted. According to me, he is alive.
He is still alive.
Hmm.
He is still alive.
Lordship, owner has not challenged the error.
Hmm.
Owner has not challenged the error. He has not disputed it was an act policy. When it was an act policy, the liability always upon the owner of the vehicle, not against the insurance company. And question of pay and recovery does not arise, Lordship, when the insurance company has no liability, when there is no coverage for the occupant. Here is also judgments of the apex court, Lordship. Lordship, covered case, Lordship. It is
Which
also
one? Paragraph?
paragraph, Lordship. On paragraph 26, Lordship, the apex court has also observed that pillion rider of two-wheeler vehicle may not be treated as a third party when the accident had taken place owing to the rash and negligent driving of two-wheeler vehicle which the deceased was riding as a pillion rider, not on the part of the another vehicle in the insurance claim. Also, there is no dispute to the fact that deceased was the pillion rider of the vehicle involved in the accident at the time of accident, and no other vehicle was involved in the accident. It appears from the insurance policy available on the record that no extra premium has been paid for covering the risks of the pillion rider of the motorcycle which was insured. Hence, in view of the ruling of the apex court cited here, the pillion rider of a two-wheeler may not be treated as third party, and the insurance policy of the appellant may not be burdened with the tax of inherent owner for the payment of compensation awarded to the respondent of 1, 2, 3 by the motor accident claim tribunal to cleansing. Thus, in view of the discussion made herein, this court is considered opinion that the motor accident claim tribunal has failed to appreciate the effect involved in the investigation of Spencer and erroneously come to a conclusion that the insurance company is liable to pay compensation amount to the death of the pillion rider of the vehicle due to the motor vehicle accident. In view of the discussion made about this appeal is allowed in part. And Lordship.
Yes, that
And-
comes against you, your
and-
submission.
Apex court decision also,
This
My
comes
part-
against your submission.
My submission is, my lord, since the matter is pending before the apex court, I have this, because in the judgment of, in the latest judgment of this, from 2009 to 2013, the last 2013 last judgment
This
is
is a
there.
latest judgment.
In 2003, the insurance company, my lord, this is the judgment last part. This is, it was referred to the, it referred to the larger bench of the Supreme Court. It was decided earlier. So in the meantime, pain recovery is there, my lord.
Mighty.
Pain recovery is always there.
Pain-
Always there.
No, regarding Lordship, Apex pain recovery is not there. Lordship, this is the judgment of the Apex court, Lordship.
This is the last part, page para 26. And last part, pain recovery is there, my lord.
But he's saying that in act only policy pain recovery.
That is his version, but the Supreme Court.
No, no, version.
That is his version. I cannot resist him because he has the privilege to say.
Where Oriental Insurance.
26, Rajupal, 2013 judgment, para 26, last part, my lord. So I leave it to your lordship to decide the pay and recovery. Last 26.
Yes, it was a goods carriage.
Yes,
It's not a pillion, he was not a pillion.
this is
rider.
not clear, but the pen recovery is
But
there.
he has submitted that he has submitted a judgment where pillion rider in connection with pillion rider, there is no pay and recovery.
Yes.
And it has been held by this court recently in 2024.
So that may be decided by your lordship.
No, no, but this is a goods carrier. It is not
This, yes.
similar to your to
Yes.
the judgment he has submitted.
And
So this is what it is.
Yes.
I'll decide it, but this is
Yes.
what it is.
It is up to your decision because your lordship is well aware about the pen recovery.
And regarding Lordship, 2007 judgment, Lordship, Oriental Insurance Company versus Mina Veria. Lordship, kindly see the para number 26. Para number 26. On the facts of this case, there is no finding that the Mahmood Hassan, another employee of the owner, was driving the vehicle, even if he was, there is no finding of his negligence. The victim of the regional manager of the company that owned the car. He was driving he was using the car given to him by the company for use, whether he treated owner of the vehicle or as an employee. He is not covered by the insurance company taken in terms of the act without any special contract, since there is no award under the Workman Compensation Act that is required to be satisfied by the insurer. In this circumstance, we hold that the appellant insurance company is not liable to name the insured and also not obliged to satisfy the award of the premium and then have to request the insured, the owner of
Because he
the.
was an employee.
That's it.
Ah,
So when as
he
per the
was an employee. Here, in this case, he was not an employee.
as per the insurance, when there was no liability, then that's it.
No, 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 this is not similar to your case. There, he was an employee in this case. He's an employee, working compensation.
Thereafter judgment came by lord 2009 when this matter was referred to larger bench, my lord. 2009, 7 SSC 148. Your lordship is well aware about this.
Which one?
This Baigyoloki versus United Intentions.
Let me see.
2009, 7 SSC 148. I have this. last part, my lordship.
Yes. Okay, refer to the larger
Yes,
bench
yes,
relating to act only policy.
yes.
I think there's a good case.
As per the recent judgment of the apex court also lordship, regarding the act policy, the insurance company is not liable. The recent judgment also. I can produce it.
Yes. Today? Or some other day? Tomorrow, day after tomorrow,
But it can be next Tuesday,
next week?
next week.
Part and arguments submitted by both the sides, list the matter on 9 September.
This second may be also taken on 9.
9 or 9,
9.
as agreed by, Arun Nukun list. There are many cases, some other day,
My lord, after lots of trouble, my lord, could be listed, my lord. So
11 on 11,
11th,
11.
my lord.
as agreed by both the sides, list the matter on 11 September.
Much more.
May it please your lord. Your lordship, my senior counsel will read the matter as for the fact that he is not able to come to the court today because of some personal difficulty. Can a date may be fixed?
Lordship, the date has been fixed. Let it be after vacation, your lordship.
After vacation, as agreed by both the sides, list the matter after vacation.
A date may be fixed, your lordship.
Date at the Jackson, list the matter on 30 October,
Before that, your lordship.
before, so 28 October,
Oblige, your lordship.
okay.
And for the appellant, lordship. Yes.
Hearing,
Yes, yes.
what about the other side?
Other side was sitting there, lordship. May I start, lordship?
No, but if they don't turn up, then,
Lordship. And after some time.
yeah.
lordship.
It's the lordship.
This is an appeal where we have challenged the liability of the insurance company, lordship. In fact, there is some doubt over the whole version of how the accident had occurred. In this case, right from the beginning, there is a reluctance on the part of the claimant to state how the accident had occurred. A motorcycle is, the insured motorcycle is stated to be involved. But the version of in the claim petition stated, when my husband was going on by the correct side of the road, the insured vehicle came and hit him. Correct side road, whether he was going by on foot or by motorcycle or whatever, there is absolute reluctance. Even in the affidavit, lordship, the same way, there is absolute reluctance to state how he was proceeding. If he was on foot, then the insured vehicle goes and hits him, then of course liability is obvious. But in the, there are some other factors also here. The FIR was lost after 19 days. Both the motorcycle owner and the claimant are from the same village.
If I was lost after 19 days.
19.
Yes, 19 days.
Now, 1 9,
And lordship,
19 days.
19 days.
And the same motorcycle was seized after 3 months and 20 days. Somewhere. It's not even seized on the same day. But in the
Owner of bike and claimant from same
cross-examination,
village.
Lordship,
Owner of bike and claimant from same village.
same things. The address appears to be same. So there ought not to have been any delay in saying, well, I have
That
knocked the yes.
Pending motorcycle was seized after 3 months.
After 3 months. They're all recorded facts. Lordship. And FIR itself was filed after 19 years. Then also in the year Lordship cross-examination, the claimant says that my husband was riding a motorcycle when the other motorcycle came and hit. This creates a clear contradiction. Leading is that presumed to be, they are trying to say he was walking, but not the man's word walking or on foot was not mentioned in the claim petition. This is obvious reluctance to say how he was proceeding. Maybe it's a case of you have two vehicles. Somehow I cannot deny the involvement of my vehicle. Because the owner has come willingly to say that his vehicle was involved. He's denying it as a negligence, but his vehicle was involved. So I cannot now take a difference that my vehicle was not involved. But the manner of accident, manner in which how the accident occurred, is lives here. Then there's a settled position of law, Lordship, now after that Lalita Kumar's judgment versus State of UP, that there should be a GD entry, which is there, it's there in almost all cases. In this case, Lordship, there is no GD entry. The insurance company had brought a police officer to of the Sortebury police station to examine the record. There is no GD entry in Sortebury police station. It normally happens. There is a GD entry, and that GD entry is supposed to be considered as a FIR in that 5 judge constitutional bench judgment. The GD entry has the same footing. It has to be done when the later an FIR is filed. They are both to be crossed. Like GD entry number has to be there in the FIR, and FIR has to be there. That is a settled position. There is no doubt about that. GD entry occupies almost the same importance. There is the same importance as the FIR. So in this case, there is no GD entry, which should have been there. This raises another controversy. Why is there no GD entry? When the police officer said there is no GD entry in that police station on that day. Now see, it's possibly there are other points on this point. I'll come to the high income and other loss. It looks like there's an involvement of the insured, the deceased was also going by motorcycle. Because it has come from the mouth of the claimant. That husband was riding a motorcycle when the motorcycle number 739, the insured vehicle, came and hit him. My first suggestion, Lordship, is that it's a case of contributory negligence. Some negligence is being sought to be suppressed. The delay in filing the FIR is one reason to be suspicious about why was the FIR delayed. Then the difference between the pleading and the evidence. That is also one. The other, Lordship, my learned friend will have something to say. I'll go to the other points, Lordship. This is one point. And there is also no eyewitness, Lordship. No GD entry, no eyewitness. Delay in FIR. All these things couple have created a reasonable doubt in the mind of, it will get reasonable doubt in the mind of whether the version has been correctly projected.
So why didn't you allow investigation from your investigator?
We had called the police officer also. And he said there is no FIR, no GD entry in that police station. So that's the part we can do. Other than anything, even if our goes and says something, that has to carry some credibility. I've also challenged the income. This is an accident of Lordship in the year 2014. Income at that, national income at that time point used to be lesser than 6,000. It was considered 6,000. It's after about 11 years back. Even now it goes around 6,000, 7,000, 8,000. It was that's ground number 6 is this. And there's no document was proved Lordship to prove the income. Then future prospect, of course, he'd be entitled. I have taken it as a ground, but that I will not press because future prospect anyone is entitled to. Only that amount also, loss of consortium was awarded 1 lakh and standard 70,000. Loss of these two standardized out of the price. So that part, loss of consortium part, etc., that has to be. This is broadly my yellow. I leave it to your lordship after this.
May I please, your lordship?
You
My
have
lord-
claimant?
I am the claimant side, man. My lord, here in this case, my lord, my learned friend nicely submitted before your lordship. Accident took place at night, at 10 p.m., not at 9:30 p.m. My lord, your lordship kindly consider, since in the night accident took place, whether the person who accompanied with the, my lord, injured, whether he should go to the police station first or to the hospital, my lord. My lord, what happened, my lord? Immediately after the accident, such a serious accident, the injured was taken to the Borpeta Civil Hospital at my lord, 12 at the night, my lord. My lord, your lordship kindly go through the judgment. Only paragraph 6 and 9, your lordship will come to the clear, my lord. May I read, my lord? Very clear, my lord. My lord, in fact, my lord, FIR lost after 19 days. There is a specific ground delay has been explained in the, my lord, in the FIR, my lord. My lord, now your lordship, they have examined the one PW, my lord. PW1, he is a police inspector, my lord. He is an investigating officer, my lord. He has clearly said, your lordship, just see the paragraph 6, my lord. May I read, my lord?
Page?
Then page 16, my lord, is very clear, my lord. In fact, my lord, this is injured was taken first to the hospital in the night hour. And FIR was lost after 19 days, admittedly, my lord. There is a cause of delay in the FIR. My lord, page 16, paragraph 6, my lord. On the other hand, the contesting OP number 2, insurance company has adduced one witness, namely Sri Nurul Islam Talukdar, ASI of Police of Sartebari PS, as DW1 who deposed from the FD, my lord, it may be CD mode, my lord, I think, my lord, CD of the Sartebari PS for the month of September 2014, that no GD entry had been made on so and so, on the date of accident. That is the date of accident, my lord. In respect of the accident involving motorcycle bearing registration number so and so, in which the person, namely Sanjit Medi, had died. He further stated that on so and so, no accidental case was recorded by GDNT number 15514. It is also stated by him that as per the copy of the postmortem report, your lordship can see, very important. Postmortem report, it appears that, it's apparent that the aforesaid GDNT was from the FAA Medical College and Hospital. The PP, according to him, in some accidental case, the injured are taken to the hospital, and in such a case, entry is made before postmortem in the nearest police station. Now, your lordship kindly see, I have heard the argument advanced by the learned counsel of both sides and peruse the materials. Paragraph 9, your lordship, it is clear, my lord. Paragraph 9. OP number 1 did not raise any dispute regarding the accident, but OP number 3, insurance company has denied the same into the sort and established by adducing evidence that no accident had taken place as alleged at Rampur New Chowk on the given date at time, and the case is false and planeted one. The learned counsel for the opposite party number 2, Mr. K.K. Agoral, has vehemently argued that the police officer's evidence DW1 proves that concerned PS was not at all aware about the occurrence of any such accident within its jurisdiction, and in such a LS accident cannot be accepted to be established.
the argument and the contention of the OP number 3 cannot be sustained for the fact that there is no law that mandates that the each and every accident must be reported to the police station is taken care by the doctor, and the same is to be practicable and humanly impossible. DW1 himself stated that all the accident injury are not reported to the jurisdictional peers. My lord, important, my lord. Moreover, the GDNT number so and so, dated so and so, Borpeta Medical College and Hospital, PP, shows dead body was deceased Sanjit Medi was taken to the casualty department of Borpeta Medical College and Hospital in the midnight, my lord. He was taken in the midnight. And postmortem says, my lord, at 12, 12,
It's okay.
my lord. And the LS accident had taken place at 9:30 AM. It is almost instantaneous. The PM report of the deceased had shown that it has done within 10-12 hours of the deceased, and the death was result from the antemortem head injury caused by blunt force impact. The nature of the injury suggested deceased Sanjit Medi might have died in a motor vehicular accident. Claimant short per. My lord, this is the background, my lord. My lord, immediately after accident, he was shifted to medical. In the midnight, he died. Immediately, lordship, kindly see the postmortem report exhibit. Exhibit, my lord, 3, my lord. Exhibit 3, it has been, my lord, mentioned FAA Fakhruddin Ali Ahmed PP GDNT number 15514. My lord, time, my lord, 12.
Yes, yes, it's given in the judgment itself.
Yes, my lord, in the judgment, my lord. And my lord, my learned friend has alleged that the FIR was lost after 19 days. Yes, my lord. My lord, your lordship kindly see the, my lord, explanation in the FIR. Exhibit, my lord, 1. মৃতকৰ সৎকাৰৰ কাৰ্যত তথা হুকৰ কাৰণে এজাহাৰ দাখিল কৰাত পলম হ'ল. What is the, my lord, defect on the part of the claimant side, my lord? Maybe, my lord, FIR has been lost after 1 month, 20 days delayed. That is not cause, my lord. My lord, since, my lord, the accident took place in the night hour, immediately he was shifted to medical. In the medical, he died. A GDNT has been caused in the PM report. What more is required, my lord? On the other hand, your lordship kindly see exhibit 2, the postmortem report. Exhibit 3 is the, my lord, police report. Charge sheeted, my lord, exhibit 6, 4. What required, my lord? Prima facie, my lord, those are documents produced by the police. Police also examined, he admitted. My lord, this is my, on the other hand, my lord, regarding, my lord, suspicion of the accident, it is very clear, my lord. On the other hand, in other head, your lordship kindly see, as per PM report, he was 34 years. Age group comes 31 to 35. Multiplier 16. Very nightly, my lord, held, my lord, by the learned tribunal. Future prospect, my learned friend has admitted 40% future prospects. Income 6,000, very reasonable. Deduction.
I'll come back and pass
Yes,
the,
my lord.
dictate the judgment.
Yes, my lord.
I'll
Very
come back.
simple, my lord. Nothing suspicion here, my lord.
2 points to that.
Okay.
I just wanted to point.
Yes.
First thing, he said that there is someone was accompanying that deceased in the, there's no one. The affair does not reveal that there was someone with him who could have been the lordship. And second, lordship, the learned member himself was lordship had admitted this. I'm reading from para 9 that he had read. Although the accident and involvement of one motorcycle being registered number is established, there is absolute ambiguity regarding the manner of accident. That's what I'm trying to say, lordship. There's reluctance from the beginning, how he was going and how the accident occurred. The learned member has come to the same conclusion. But just because it's a beneficial legislation, it has been considered in favor. My point is, lordship, there probably was an involvement of the vehicle as indicated. and there is probably some contributory negligence. Otherwise, this doesn't. It amounts to a fraudulent suppression of material.
Regarding contributing negligence,
No,
no plea has been
more-
taken in the lower court, my lord.
Present Lordship, as regard that GD entry 155, almost Lordship, all medical colleges, they have a police outpost in the campus.
Yes.
That has to be entered because that's the reason why it's there. That does not equivalent to GD entry normally made in a police station, because that GD entry reveals how the accident occurred or someone has found it. Here it's simply dead body has been brought in and that is being there. These medical college GD entries do not contain such details. I've seen medical college GD entry. That GD entry, and after 18 days, the brother is not a wife who is. We are not expecting a wife to go to a police station. It's family members were there. They could have gone to a police station the next day. Why 19 days? Because there are some factors which had to be manipulated. That is the reason. Why was the motorcycle seized after 3 months? Again, another reason. A lot of things had to be problem managed, Lordship. That's the reason why. And other things like I leave to your Lordship, income and that, and loss of that part, Lordship. That's legally it has to be lesser than that. Because Lordship, if I may say one line, Lordship, in on that particular point. But before pronouncing, there used to be judgments which used to award 1 lakh for loss of consortium. Then loss of consortium was also was given to the parents. There are a lot of judgments. I have a ready argument on that particular point. So what happened is Pronacity took all these divergences into consideration and it's standardizing. After that, Lordship, there have been decisions where there has been vertical proliferations that has stopped 40,000 is the cap. But there has been a lot of horizontal proliferations. It's being given to all family members. When Pronacity as a 5-judge bench was definitely aware of the Indian family and had decided to give it to only the spouse, meaning either way, only spouse. It would have also made a provision for all family members, but did not do so. But there's some
Susila
judges.
Agarwala.
Lordship?
In Susila Agarwala, the other family members are included now.
Yes.
From Susila Agarwala.
They are judgments. I mean, there have been judgment deviations from that Pronacity. I'm not going to legal permissibility of this. How after 5-judge bench, judgment can be modified or that judgment can be analyzed, modified. Yeah. If there is a point, untouched point, yes.
You want me to bring down the loss of consortium?
Yes, Lordship. That loss of consortium should be, Lordship, as per year, Lordship.
Pronacity.
Yes, Lord.
My lord, only one submission.
I'll come back and I'll dictate the order. If you want to submit, you'll submit then. Only 5 minutes.
Even before that Pronacity, parents used to be given, but Pronacity did not give it. Their judgment to that effect. Even parents used to get 50,000, it's 1 lakh.
It must be seen whether this judgment was passed before or after Pronacity.
It's after Pronacity. After Pronacity. No? Get the judgment too?
Pronacity was first 14 in the.
Appeal was filed in 18. Or judgment is 18.
Then it will be before Pronacity.
15, 11, 17 after Pronacity.
After.
After 15, 11, 17.
Only thing, my lord, is lordship.
I'll come back, I'll come back. Matil, I'll come back. I'll dictate the judgment in your presence. And learned counsel, Mr.
A Mannap.
A Mannap for the respondent number 1 to
5.
What about respondent number 6?
My lord, he has appeared, my lord, as per my information, he is coming from another side. He is not, he will come after sometimes, my lord.
Okay.
He has no, my lord, submission at all, my lord. He is
Respondent number 6?
He is, my lord, owner, my lord. Owner and driver. He is not relevant, my lord.
Owner and driver.
Owner and driver.
So he will.
Not
interested.
relevant.
Okay. This appeal is referred against the judgment and order dated 15/11/2017 passed by the learned member MSCT Borpeta in connection with MSC case number 686/2015. Full stop. The appellant is aggrieved by the award to the tune of rupees 14,49,600 which was directed to be paid by the appellant, insurance company. Full stop. It is submitted on behalf of the appellant that the claim petition was very vague. Full stop. It could not be, it was not discernible whether the accident was between two vehicles or whether the deceased was proceeding on foot when the accident took place. Full stop. It is further contended that the FIR was lodged after 19 days of the accident and the motorbike in connection with the FIR was seized after 3 months, which cast a shadow of doubt over the claim. Full stop. It is further submitted that the owner and the owner of the bike and the claimant may be in cohorts, COHORTS, as they are from the same village. Full stop. Much later, at the time of cross-examination of the claimant, it could be learned that her husband met with an accident, as he was riding a bike. Full stop. There was not a hint in the claim petition that the deceased was riding a bike at the time of the accident. Full stop. No GD entry was registered in the police station. Full stop. It is a settled law that the GD entry and the FIR are on the same footing, and as no GD entry relating to the accident on the date of the incident was entered, this too casts a shadow of doubt over the veracity of the claim. Full stop. It has to be assumed that the deceased was traveling by bike at the time of the accident, as there was no eyewitness to the accident, and as the claim petition was very vague while narrating the incident. Full stop. The insurer is also aggrieved by the notional income taken up for calculation of loss of dependency at the rate of rupees 6,000. It is submitted that the accident occurred in the year 2011, no?
Yes, please.
2011? In the year 2011. And
Which one, Lordship?
Accident occurred in the year 2011. I'll check.
14, my lord, 2014. 2011, 9, 2014.
11 and
In the
2014.
year 2014, and at that time, the notional income was calculated at rupees 3,000 per month and not rupees 6,000. Full stop. If the accident was between two motorcycles, the learned tribunal ought to have held to be an incident of contributory negligence, but the entire liability was burdened to the insurer. It is further submitted that the loss of consortium was taken at a higher rate at 2,000 or at 1 lakh, which is against the decision of the Honorable Supreme Court in what is the citation. There is some insurance company versus Pranay Sethi, no?
National
National Insurance.
National
National
Insurance
Insurance
Company
Company
Limited versus
Versus Pranay Sethi reported in
reported in, my lord,
2017. It was 2017-16, SCC 680.
per contra, the learned counsel for the claimant laid stress in his argument that the accident took place at night at about 8:30 PM or 9:30 PM?
9:30 PM.
At about 9:30 PM. Who stops? Thus immediately, the deceased was shifted to Borpeta Civil Hospital. Who stop? It is not possible that in a serious accident, any family member will rush to the police station instead of taking the deceased to the, instead of taking the injured person to the civil, to the hospital. Full stop. The GD entry registered at the, what is it called? PP, no?
Hospital PP, my lord.
Hospital, what is it called?
Petrol post, my lord.
Hospital petrol
Petrol
post.
post, my lord.
At the
Police
hospital,
station, like police station, my lord.
police post.
Police post, my lord.
At the hospital police post, within bracket PP, clearly reflects that the GD entry was registered immediately after the accident, in the in the intervening night of the accident, immediately in the intervening, no, intervening, no, immediately after the accident. Full stop. I.e. DD entry number 155 dated 12/9/2040, whereas the accident took place on 11/9/2014.
He died, my lord, after 12 PM. That's
Yes.
why, my lord, 12, dated 12.
Yes,
my lord.
okay. The FIR, which was lodged after 19 days, clearly explains and justifies the delay in lodgement of the FIR. So it has been categorically mentioned in the FIR that delay was owing to observing, delay was due to the funeral rites observed by the family members. Full stop. It is a clear case of accident and no suspicion to the conduct of the claimant as alleged by the insurer is discernible. Full stop. I have considered the submissions at the bar. Full stop. Now I do not, I have considered pass out. So it has been held by the tribunal that the insurer did not raise any objection and emphasized that that a false and a planted case has been brought up against the insurance company. Full stop. Has been brought up, full stop. It is tribunal, no? it was held that the argument and the contention of the insurer could not be sustained for the fact that there is no law that mandates that each and every accident must be reported to the police before it is taken care of by a doctor. And the same may not be practicable and humanly possible, full stop. It was held that the GD entry dated 155, GD entry number 155 dated 12/9/2014 reveals that the body of the deceased, Sanjit Medi, was immediately taken to the casualty department of Borpeta Medical College and Hospital at midnight, i.e. 12:30 AM, full stop. PM report reveals that the PM was performed, PM report reveals that the postmortem was performed within 10.20 hours. And the death was the consequence, death was the result of coma and was opined to be antemortem. As a result of head injury caused by blunt force impact, full stop. After scrutinizing the documentary evidence and assessing the oral evidence, it was held that death of Sanjit Medi in a motor vehicular accident on 11/9/2014 at Rampur Chowk and the involvement of the motorcycle bearing registration number AS01/MA-7931 stands established. It was held that the contention of the your OP number 2 or 3, insurer? OP number 2 or 3?
No, sir, as open number two.
2, no?
Because only open number one is driver come out.
Yes, yes.
Second is the
It was held that the contention of the insurer that it was a planted case could not garner any substance, full stop. It was also observed by the tribunal, next paragraph, it was also observed by the tribunal that indeed the involvement of one motorcycle bearing registration number AL01/MA-7931 was ambiguous, full stop. CW1 claimant. CW1 is the claimant, no?
My lord,
CW1 is the claimant, no?
claimant, my lord. CW1 claimant.
CW1, claimant. অকমান পাছত কথা পাতিব নেকি? অলপ ডিষ্টাৰ্ব হৈছে। It was observed that the claimants, CW1 in a cross-examination indeed stated that her husband was riding a motorcycle at the time of the accident, but the police submitted charge sheet against the driver of the motorcycle, OP number 1, or owner of the motorcycle, OP number 1. On the touchstone of preponderance of probabilities, and considering that this is a beneficial legislation, it was held that the OP number 1 was riding the motorcycle AS01 hyphen stroke MA hyphen 7391, and the motorcycle is an offending vehicle stood established. Stood firm, liquidity. Stood firm, full stop. Stood established, liquidity. It was held that the OP number 1, i.e. owner cum rider of the motorcycle, failed to rebut the allegation by producing any substantive evidence that the motorcycle was not driven in a rash and negligent manner. Did it take the judgment half up to it.
The other hand, my lord, owner cum driver, OP number 1, he has filed, my lord, WS. Yes, in fact, he has admitted fact. This is
No, I haven't said he has admitted. He said, my involvement, I cannot deny involvement because owner of the vehicle has come and admitted.
my lord, he has admitted in his WS, my lord.
I'm absolutely saying.
But it has not been observed. What I am dictating is what the tribunal
Yes,
said.
yes, my lord.
So it has been observed in that manner, so I am not, this is the version of the tribunal.
Yes, my lord, exactly.
He uses. It's more dictation because of our no. And I'm for taking the human disturb for say dictation.
Yes.
Thereafter, comma, considering the age of the deceased and the legal heirs, the tribunal awarded the compensation in favor of the claimant, directing the insurer and exonerating the owner, directing the insurer to pay the compensation and exonerating the owner of the motorcycle from paying the compensation. Full stop. I've considered the submissions at the bar with circumspection. The point for determination in this case is that whether the learned tribunal has erred by holding the, erred by holding the erred. What is your, what is only one, it has to come down to only 1 or 2 points. What are your basic points?
Basically, points was whether this is a case of sole negligence of
Okay.
involved vehicle because the vehicle is in.
Only one vehicle responsible for the accident. And another? Any
It
other?
was lordship, the income and the loss of consortium, that part is on the higher side.
In-
One is regarding
And no,
nature of the accident.
okay, all right. And whether the number 2, likh diya, the income was erroneously assessed by the learned tribunal to be 6,000 instead of the notional income which was prevalent at that point of time. Full stop. The genesis, the genesis of the case was that
Regarding my lord, contributory negligence, as my learned friend is my lord submitting, my lord, unless and until it has been probed regarding contributory negligence, it cannot be said, my lord, there is no whisper in there.
I will add it. You just remind me, I am during the conclusion part, you just
Madam,
remind me, I'll add it,
Madam.
definitely, that that WS has been submitted, that he has admitted that he was at fault.
My lord,
You just remind me.
my lord.
It will take me only another 5-10 minutes, then you can just remind me. We do not have the trial court record. Huh? Scan copy. Give me scan copy. Original क्यों नहीं? Scan copy. Only scan copy आगा. Not then. This was scanners. Hopefully also appreciate. Scan copy के लिए दिया है. ये काफी सारी on 11/9/2014 at about 9:30 PM, comma, Sanjit Mehdi was proceeding from Rampur New Chowk towards his residence at village Rampur, Kashkuri, KSHKURI, Kashkuri Pothar, PATHAR, on the correct side of the road. To stop suddenly, see, there's a word vehicle mentioned in the claim petition. But it was mentioned in a very insinuating way. My vehicle has been mentioned in the claim petition.
Yes.
Yes.
What I'm saying, Lordship, vehicle has been mentioned,
Uh,
but how the accident occurred, there is some reluctance.
yes.
No one is saying he was on foot or on a vehicle.
No, but
The wife
vehicle
says he
is
was on a
mentioned.
vehicle, otherwise it's plain, plain it says he was walking. So there is contradiction. Even London member has taken note of it. There's
Yes.
ambiguity. He has taken note of it.
Suddenly, another vehicle bearing registration number AS01MA hyphen, another vehicle nalage. Suddenly, a motorcycle likhe diya. A motorcycle bearing vehicle registration number AS01MA 7391 knocked Sanjeet Medhi within bracket herein after also referred to as the victim or the deceased. Bracket close. From the back side, full stop, the motorcycle was driven in a rash and negligent manner. And the deceased sustained grievous injuries and was immediately brought to FAAMCH, capital, comma, Borpeta, and for treatment, but he succumbed to his injuries in the hospital. Full stop. The body was forwarded for post-mortem. Full stop. Regarding the incident, Sotabari PS case number 252/2014 under section 279/304 AIPC was registered. Full stop. The claimant also, the claimants, comma, legal heirs being wife, comma, son, daughter, wife, comma, children, two children, wife, comma, two children. Yes. And parents of the deceased. Filed a claim petition. Filed this claim petition for compensation. Full stop. Apurva Talukdar, the owner and driver of the motorcycle number 7391 and the insurer of the motorcycle were arrayed as respondent number arrayed as opposite parties number 1 and 2 respectively. At this juncture, it is pertinent to mention that the opposite party number 1, I, the driver and the owner, I have included your submission. Owner of the motorcycle filed written statement and admitted that the accident took place due to the rash and negligent, due to his rash and negligent act. The post of the driver and owner prayed for exoneration as his vehicle was duly insured at the time of the accident and he was holding a valid at the time of the accident, लिखिला ना? And as he was holding a valid driving license at the time of the accident. I have also, I have also reappreciated the evidence, both oral and documentary evidence. Who stopped there, so I'll dismiss it. I'll dismiss it.
It's lordship on the point of lordship, quantum of compensation.
Mm.
The loss of constituent part that can be considered
What loss of?
income part and loss of that quantum part. Maybe
No,
ground is not, main ground is not,
That income in 2014, notional income, is it 3,000?
no, not it. I didn't say 3,000. It can be even lower than 6,000 also. Per day it was around 1 lakh, minimum wage it was 160 rupees per day around. In 2015, it is 133 in 2013. Even by going by minimum wages, it can be tempered a bit, let's say 5,000 can be considered, if not 6,000. Because 160 into 30, it comes to 4,800. Okay, maybe 5,000 could have been, no, because now it's considered as per minimum wages.
Mm.
Generally, it's now minimum wages
Do
accepted by
you
all.
have any document, supporting
Right.
document
Here,
relating to
right.
minimum wages?
And right now, let's say I didn't bring the document with me. Can you provide it tomorrow or day after? Not today, I can have to go home and find out. Based on that,
No,
whatever
no,
it
but I
comes,
have already decided that I'll dismiss it, a little bit of tinkering here and there I can make, but I cannot fix it for another day.
just that income part 5,000,
No, no.
based on minimum wage. I'm
He
saying
was, he
based
was,
on
my lord,
minimum wage.
34 years.
Let him furnish a copy of notification, I don't mind. If he has to-
34 years old, my lord. He is, my lord, maintaining such a members of the family, wife, 2 children, parents. My lord, 6,000 very nominal, my lord. I think, my lord.
Then I'll leave it to your lordship, lordship. But minimum wage is now provided basis, so that can be considered. Yeah,
But
please, okay, fine.
please remain armed with your weapons on the other days, because why I'm saying I do not have any
I
documents
leave
now.
it to your lordship. You know, loss of constituent part, if that is,
He's admitting.
Now if you can furnish from the Google or anything, then I can accept it. If you can furnish from AI or anything, I'll accept it. I'm still on dictating. It will
maybe
keep
lordship,
going up.
during lunchtime, lordship, I can make an effort. during
No,
lunchtime.
no, no. Then I'll
I'm
dismiss
sorry,
it.
I'm not ready to do
We have
it.
10 minutes. You can do, within 10 minutes, you can furnish, then
Just try, lordship.
it has been correctly held by the learned trial court that thus it has been correctly held by the learned trial court that the OP number 1, the driver and the owner of the vehicle bearing registration number 1, MA 7391 was responsible for the accident. Full stop. The evidence clearly reflects that the accident occurred accident occurred on 11/9/2014. And immediately, as the deceased was as the victim was in a critical condition, he was shifted to the Borpeta Medical Hospital, and thus instead of proceeding to the police station, full stop. The GD entry number 155/2014 dated 12/9/2014 is proof enough of the fact that the victim was immediately shifted to the FAA Medical College and Hospital, and he succumbed to his injuries in the hospital. Full stop. the age was correctly taken. The age was correctly assessed after. Now age was correctly assessed. Exhibit 1 is the FIR which was indeed registered after 19 days of the accident. Because of it, the reasons of delay has been explained in the FIR, Exhibit 1. The FIR was lost by the brother of the deceased, Dhanjit Methi, who has explained the reasons of delay that they were busy shifting the deceased to the emergency room and after this has not been explained, I think. No, there was no explanation in the FIR.
My lord,
Brother of the deceased has lost the FIR.
my lord, FIR was lost by my lord, brother.
Brother.
Brother, my lord.
There's no explanation.
Yes, my lord. There is
Explanation of delay I cannot find.
a delay is there, my lord. As explanation, my lord.
The PS, there's a PS, that metaphor Hotkara for Karna.
My lord, last portion, my lord. NB Mitokor, Hotkar.
Oh, yes.
That was, I
Below my
think
lord,
the
below
brother
side.
could have done it even after 1 or 2
Yes,
days.
yes.
Even widow is
The
not
delay has
expected to
been
do it.
Explained by the brother of the deceased that he was busy with his, with the funeral rites of the deceased, full stop. On the contrary, it has been submitted by the learned counsel for the insurer that the brother could have easily lost the FIR after a few days of the accident, after a day or two after the accident, full stop. However, it is held that the learned tribunal has accepted the explanation for delay in the lodgement of the FIR and no interference is required at this stage. The AIR marked as exhibit two clearly reflects that the offending vehicle was duly insured at the time of the incident and the insurance was valid up and the policy was valid up to 6/8/2015. And so was the driving license of the driver, which was valid up to 31/5/2013. In view of the foregoing discussions, it is thereby held that I thereby record my concurrence to the decision of the learned tribunal. The appeal is hereby dismissed. Okay. Quantum of compensation also,
Lordship,
if you could have given me something now, so I am dismissing the appeal.
I'm sorry, I am underprepared today.
Yes. Okay.
Sorry, ma'am, I have.
And the judgment of the learned tribunal dated so and so is upheld.
My appearance may be recorded. ma'am. I have
Yes.
appeared on behalf of respondent
Your
number
name,
6,
your name,
J. Hussain,
J. Hussain.
for respondent number 6, owner cum driver.
Lordship, one line about that refund of
Yes.
statutory deposit. Lordship.
Respondent number 6.
The insurer is allowed to withdraw the statutory deposit. Yes.
May be refunded on.
Yes. I'll send back the trial court record, nalage, to scan copies.
Obliged, Lordship.
Any short submission for adjournment or anything?
My lord, for item number 20, my lord.
Hmm.
It may be come up on any other day, my lord.
I am for the appellant. Before vacation, if possible,
My
Lordship,
lord.
then I have no objection.
I'm so sorry, not possible before vacation because we are, docket is full before vacation.
We want to do is before vacation, Lordship, and the plaintiff and Lordship, it's a case of remand only. I have filed one. have
I will
filed
submit
additional-
in this issue, my lord. That's why I am taking time, my lord.
Filing before vacation.
Only
It
half
won't
an,
reach, it won't
it
reach.
will take only half an hour, Lordship.
Lordship,
Supreme Court.
Today,
decision,
not
Lordship.
possible, my lord. I am praying for
Before vacation, I'm saying.
before vacation, my lord. On 23rd, my lord.
Take half an hour and how much time will you take?
Lordship, 20.
My lord, I am not prepared, my lord, basically. I am not prepared, my lord. And this appeal is, in my opinion, my lord, it's liable to be dismissed.
16,
16 or 23, my lord.
16.
Not on 23, only on 16.
23.
Filing is 16. 18, on 18.
It's a Thursday, Lordship.
Item
18 not
24 can be adjourned for the-
Right, right?
Item
Obliged,
24,
Lordship.
Lordship.
I think.
The hearing which are.
Edu kiman asile, kiman
I-
24.
No, it's not. Item 20 on Lordship, 18
On 18 September. Obliged, my lord.
Item 24, Lordship. I would take consent by other side, Lordship.
Learned counsel Mr. R. Goswami, the consent of the other side has prayed for adjournment. List the matter after vacation? After Puja vacation.
My lord, item 26, my lord. Kindly adjourn the matter, my lord.
Have
I
you
have-
taken consent from the other side?
Yes, my lord. Yes, my lord.
Learned counsel Mr.
M. Hussain.
N. Alam.
N. Alam.
Huh?
N. Alam.
N. Alam.
M. Hussain, my lord.
Is present for the. Oh, ulta ke likhe. Learned counsel Mr. M. Hussain is present for the appellant and learned counsel Mr. N. Alam is present for the respondent. List the matter for hearing on after Puja vacation.
My lord, a date may be fixed, my lord. Kindly,
Date at a 30 October. List the matter for hearing on 30
most
October.
of
Is
it.
your lordship, item number lordship 19 lordship.
Yes.
That may kindly be fixed after vacation lordship.
No,
Or
after-
before that,
have you
25th
taken
of
consent?
September.
Huh?
can it
No, no, my lord, this is a small, very small issue, my lord, only the point is to determine whether the writer was having a drunk or not. That is the issue to be
Before
decided.
vacation, we cannot, we
No,
cannot
that's,
accommodate.
before Puja vacation, my
We
lord.
cannot accommodate. No,
My
no.
lord, 18 will be, I think.
No, no, no. No, no, not possible. Somehow we could accommodate her.
After vacation.
Just write immediately after vacation, 14,
Yes, yes, lordship.
Okay.
19,
14th
we can list the matter on 14th October.
Must oblige lordship.
Obliged.
Record my objection. I am under pressure, Lordship. My client is
Okay.
pressurizing me.
Sure.
And Lordship may kindly fix it on 16, Lordship. He has.
No.
16.
16?
16
Lord.
or 18, any date.
He is also
65?
ready, Lordship.
I'm ready.
Not possible, not
Lordship,
possible.
only Lordship, allow for listing. If it not listed, then we'll take another date after vacation, Lordship.
Okay. Item number 17.
Lordship.
Learned counsel Ms. R. Chaudhary is present for the appellant. Learned counsel Mr.
Be there, Lordship.
P. Devi on behalf of Mr. G. Bhardwaj has prayed for adjournment. The First of the learned counsel for the appellant has raised serious objection. State list this matter for hearing positively on 16th.
Lordship, deeply offensive.
Item 21.
My lord, in this second appeal, my lord, of course, the appellant side lost in both the courts bill, but the suit is agreed and in the appeal is also failed. So it is the concurrent judgment against us, my lord. In fact, they have filed a money suit, my lord. So our basic objection was that the suit was not maintainable. It cannot be a money suit. In this context, I beg to draw your lordship attention to this memo of appeal, page 49. Exhibit 1.
You are the original defendants.
We are dependent, madam. They filed a money suit, so we raised the preliminary objection. It cannot be a money suit. So in this context, I beg to draw your lordship attention to annexure exhibit 1, my lord, page 49. This is a deed of agreement in between the parties. That is plaintiff and the respondent. It relates to a purchase of a vehicle. Like originally, vehicle was purchased by borrowing money from a financial company by the present appellant, my lord. So she having failed to pay the installment of the things, so then they became interested to purchase the same vehicle. They took the responsibility of paying the installments to the financer. So in this context, the agreement exhibit 1 was enacted in between the parties, madam. This is dated 16th October 2012. It was also drafted by an advocate. They agreed it was registered, my lord. So subsequently, they failed to carry out this agreement. The installment they ought to have paid to the company financer, they could not. So on this issue, dispute raised. They also filed a criminal case against us because their case was that we have cheated. We have cheated them. Or in the criminal case, my lord, we have enacted judgment of the criminal case here in this case also, my lord. They got defeated in the criminal case. The suit was dismissed. Their case was dismissed. So, my lord, our preliminary objection where we have raised in the written statement, page 13, my lord. Page 13, your lordship may be pleased to see. I want to read the para 2, my lord, that the suit is not maintainable in its present form and manner because it cannot be a money suit. The defendant never borrowed any money from the plaintiff that he would recover from the defendant, but there was an agreement between the plaintiff and the defendant, and without title to the amount of money he has claimed for recovery. Then, my lord, in paragraph 4, we have specifically stated, the plaintiff has no custody to file the instant suit against the defendant. It is a case of specific performance of contract, but the plaintiff severely failed to perform his part of performance agreed upon, and even if it is so agreed upon, by the plaintiff that his failure to pay the amount to 1 lakh rupees in two installments, one on the 30th November 2012 and another on the 30th January 2013. The earnest money shall be forfeited and the defendant shall have right to take the vehicle to her possessions. And it is obvious that he did not pay the said amount, and as such he has no right or title to claim the amount herein this suit mentioned. So these are these written statement of us raising the question the money suit is not maintainable was not at all considered by the courts below, my lord. They absolutely misguided with travel, both the judgment, my lord. The basic question between the parties is the exhibit 1, as I have drawn your lordship attention to page 49. This agreement, either party failed or succeeded, then for the maintenance of this specific performance of contract is here. So, my lord, in this context, I beg to draw your lordship attention to our memo of appeal, page 5, my lord. Written statement. The substantial question now arises in this appeal is as to whether the money suit number so instituted by the respondent plaintiff
Memo of
against
appeal, page 5.
my lord,
Memo of appeal, which page?
memo of appeal, my lord, page 5, my lord. It is your lordship. At the bottom, I have laid the substantial question of law. This is a written argument like something your lordship may see it later on the pages. The substantial question of law arises in this appeal is as to whether the money suit so and so instituted by the respondent plaintiff against the appellant defendant in the facts and circumstances of the agreement dated 16/10/2012, Exhibit 1, and due to its failure to be carried out by him, the impugned money suit and degree thereof are sustainable in law. The next question we have taken, my lord, the substantial question that arises in this appeal is as to whether, as per section 37 of the Indian Contract Act, the respondent plaintiff having failed to perform his part of promises in view of the evidence of PWs by not depositing promised monthly installments 46 numbers to the finance company, his instituted money suit is maintainable in the eye of law. They made a promise by due of agreement, as I had drawn your lordship attention, the 46 installments, by 46 installment month-wise, the money has to be paid by them, then only they will be entitled to get the vehicle. They have failed to do it. The substantial question of law arises as to whether, in the facts and circumstances of the matter of agreement dated 16/10/2012, in between the respondent plaintiff and the appellant defendant, the alleged money suit of the respondent plaintiff is maintainable under section 34 of the Specific Relief Act. Your lordship may be pleased to see the Specific Relief Act.
Yes, sir,
It's a
specific-
small book, madam.
Yes, sir.
Lordship, may I interrupt for a moment, Lordship? The appeal was admitted on 6/4/2023, only on one substantial question of law. And now there was no liberty given to the appellant to raise any other substantial question of law at the time of hearing. So only one substantial question of
Which
law
one?
they have to argue.
Yes.
Lordship.
Which one?
Whether the money suit number so and so is the respondent plaintiff withdrawn in act number 2.
Yes, yes, my lord. If
So
it is so, then the number
they
one
will
may be taken.
confine their argument
If
with-
it is so, my lord, the number.
কিন্তু আপনি পিয়নজনক মাতি আছেন, বর্তমান সহি বলবে। We'll limit to only the question of
Yes.
law that all
They have
formulated
to
by the court.
confine their argument within the substantial question of lordship. Only one was.
It definitely will.
So if the only one, first one is taken, this is also why it to be matter to be considered by your lawsuit.
Mm.
The substantial question arises in this appeal is as to whether the money suit number 2 instituted by the respondent plaintiff against the appellant defendant in the facts and circumstances of the agreement dated 16/10/2012, Exhibit 1, and due to its failure to carry out the impugned money suit and the degree thereof are sustainable in law. They failed to carry out, my lord. So they ought to have filed a specific, either of the party, the matters to be decided by the court on a suit under specific relief act. That having not been done, despite we having raised the objection, the suit itself is not maintainable. It is small. So in this aspect, my lord, you have written argument. Yes. There is here. What to quote? So this is a small, of course, we lost in the truth battles, my lord, but till that we are with hope fighting matter. The basic issue was not decided by the court. So on this matter, I leave it before the losses, my lord. My learned friend will argue. মতো তুমি নিলে নাকি বুঝল
9 years.
Written argument you have submitted.
Yes. We have given the written argument.
Yes.
I have not received any copy, lordship.
Did you ওটা দিল?
Either he has to argue orally, then I will reply, lordship. In written argument, whatever, what was written, I am not aware, lordship.
The copy was there ready, my lord. What happened? No.
Moreover, lordship, both the judgments are in favor of the plaintiffs.
This is their, it is the admitted fact.
I'll read the first appellate court judgment,
Double
lordship.
delay line. Have we given doubles?
That is page 35, lordship, of the memo of appeal.
Okay.
From paragraph 2, I am reading, lordship. The
Okay.
respondent plaintiff's case is, in brief, is that the appellant defendant being the registered owner of a vehicle bearing registration number so-and-so had sold it to the respondent plaintiff by way of an agreement dated 16/10/2012 and executed in presence of the pro forma respondent defendant numbers 1 and 2, witnesses before the notary public at Gwalpara. As per terms of that agreement, the respondent had paid an amount of rupees 4,90,000 to the appellant. Out of the total consideration of 8,90,000, and the remaining amount of 4 lakhs was to be paid by the respondent in 46 months EMI at the rate of 13,500 to Sriram Transport Finance Company Limited, Bongaigaon. Further, it was also stipulated in the agreement that the respondent shall have to repay the amount of rupees 1 lakh which the appellant had paid to the finance company in 2 equal installments within 30/11/12 and 30/1/13. Failing which, the appellant shall have the right to repossess the vehicle and the respondent shall have to forfeit the part payment of rupees 4,90,000. After taking delivery of the vehicle, the respondent had spent an amount of rupees 1,77,000 on its repairs. On 5/11/12, when the respondent went to the office of finance company limited at Bongaigaon to pay the EMIs at the rate of 13,500 for the vehicle. As we agreed to pay 36 installments, lordship, so 46 installments, we went to the office to pay our first installment, lordship. He learned that the appellant had failed to pay the previous 5 EMIs payable on 5/6/12, 5/7/12, 5/8/12, 5/9/12, and 5/10/12. amounting to rupees 67,500. Further, the respondent learned that the appellant has paid only one installment of rupees 16,411 on 5/5/11. Hence, the finance company also denied having received rupees 1 lakh from the appellant as stipulated in the agreement. So, Lordship, he violated the clause of the agreement, did not pay the amount to the finance company. After clearance from the appellant, we were to give 46 installments, Lordship. So first, he had violated the agreement, Lordship. Thereafter, the respondent went to the appellant on 8/11/12 and asked her to take back the vehicle and return 4,90,000. So we went that you take back your vehicle and my amount you return back to me, Lordship. And rupees 1,77,600 spent on repairs, which she did not agree. Thereafter, both sides filed criminal cases against each other, Gwalpara PS case number so and so. In due course, the vehicle was seized by police and handed over to the appellant. All these gave rise to the cause of action for the respondent to file the suit, seeking recovery of 6,67,600 from the appellant along with interest at the rate of 10% per annum. The appellant defendant's case in brief is that she had never taken any money from the respondent, and even though there was an agreement between her and the respondent had failed to perform his part of the contract as agreed upon. He did not pay the EMIs, and as such, he has no right or title to file the suit for recovery of any amount. Further, the matter of repairing of the vehicle does not have any nexus with the subject matter of the agreement, and the same is beyond her knowledge, and prior to the filing of criminal cases against each other, she had received an advocate notice dated 30/11/12 from the finance company, and even she got summon of an NI case number so and so in respect of the non-payment of the installments of the vehicle. She has denied that police had handed over the vehicle to her, rather she was given custody by the court. And so she has got no exclusive possession over the vehicle, and it is the court which has full authority over the said vehicle, hence she has prayed for dismissal of the suit with cost. Then, Lordship, 6 issues were formulated. And during trial, respondent had examined 5 witnesses and has exhibited 6 documents in support of his case, whereas the appellant has examined 3 witnesses and exhibited 3 documents to prove her stand. Grounds, Lordship, they have taken that learned trial court has erred both in law as in fact in the suit in passing the impugned judgment and decree. The learned trial court has failed to appreciate the evidence on record in passing the impugned judgment and decree. The learned trial court ought to have insisted upon production of the original agreement for sale of the vehicle, which would have been shown that the respondent violated its terms and conditions, first failure to pay 46 numbers of EMIs to the finance company. Secondly, failure to pay rupees 1 lakh to the appellant in 2 installments, thereby violating the terms of the contract. The learned trial court has failed to take into account that it is only because of failure of the respondent to pay her rupees 1 lakh for which she could not pay the finance being, which led to her in defaulting the repayment of loan, which was only because of failure of the respondent, as he broke the agreement, and therefore he is not entitled to recover the amount paid as earnest money. I have heard the arguments advanced by the learned counsel for both sides and have also gone through the pleadings, evidence on record, and the impugned judgment. Now, points for determination, Lordship, whether there is cause of action for the suit, whether the respondent is entitled to recover 6,67,600 from the appellant along with interest at the rate of 10% per annum from the date of agreement, that is 16/10/12. Both the points for determination are taken up together for discussion and decision for the sake of convenience and also for the fact that they are interrelated. The admitted position is that the appellant had purchased a vehicle truck bearing registration number so and so on loan from a finance company. In this respect, the evidence of PW5 Rakesh Kalita is worth mentioning. This witness has categorically deposed in his cross-examination that the appellant had purchased an old Tata truck vehicle bearing registration number so and so on hire purchase agreement on 25/3/11 from Sriram Transport Finance Company, Bongaigaon branch, and for that the company had financed rupees 4 lakhs to her. And as per the recitals of rupees 4, 5, and 6, the period of recovery of loan financed was fixed for a period of 4 years in 47 EMIs. However, according to PW5, after paying the first installment amounting to rupees so and so, she failed to pay the remaining 46 EMIs at the rate so fixed in the agreement. I find that the appellant by way of cross-examination has not denied these statements of PW5. Therefore, as per law, I find that the appellant was not legally entitled to enter into any agreement of sale with respondent, because as long as the loan subsists, the appellant could not have sold the vehicle to third party, as she does not have the full ownership right over the vehicle, and it is the finance company which is the owner of the vehicle. Moreover, transfer of ownership of a vehicle is covered by Motor Vehicles Act. The further admitted fact of the case is that appellant had entered into an agreement of sale of that vehicle truck with the respondent plaintiff on 16/10/12. Having gone through Exhibit 1, I find that it is a secondary piece of evidence, as the original agreement was not called for or brought on record and exhibited, and neither has the respondent set the ground for adducing secondary evidence of its contents. As per terms of Exhibit 1, I find that the appellant has admitted having received an amount of rupees 4 lakhs 90 from the appellant out of the total consideration of rupees 8 lakhs 90,000 on 16/10/12. I find that DW1 appellant has nowhere during trial or in her pleadings has denied this part of the transaction. So this 4 lakhs 90,000 is admitted, Lordship. Rather, she has admitted in her cross-examination that she has not submitted the receipt showing payment of rupees 1 lakh to the finance company. There was an agreement that she will pay 1 lakh to the finance company, Lordship. That part she has not completed, Lordship. And even though DW2 Arifuddin in his cross-examination has deposed that an amount of rupees 50,000 out of said 4 lakhs 90,000 has remained unpaid, I find that the said statement of his beyond pleading and can be taken into consideration. Rather, I find that he, being the husband of the appellant, has admitted the appellant having received 4 lakhs 90,000. Therefore, I conclude that the respondent had paid rupees 4 lakhs 90,000 to the appellant. Now let me analyze the contention of the appellant that she is entitled to repossess the vehicle and keep their part payment of so and so on the basis of evidence on record. The admitted position of the case is that the vehicle in dispute is presently in possession of the appellant. PW1 respondent has specifically deposed that he had approached the appellant on so and so and asked her to take back the vehicle and return rupees 4 lakhs 90,000. This has not been denied by the appellant. So, Lordship, there is an admission from the appellant in regard to 4 lakhs 90,000. And Lordship, we went to deposit first installment, and when the vehicle was handed over to appellant, there is no question of rest of the installments, Lordship. DW1 has specifically stated that it was the respondent who failed to pay 46 numbers of EMIs, 13,500 to the finance company, and also pay her rupees 1 lakh into installment on so and so. On the other hand, PW1 has deposed that he did not do so only because on 5/11/12 he learned from the finance company that appellant had failed to pay the previous 5 EMIs payable on so and so and the installment also. And the finance company also denied having received rupees 1 lakh from the appellant as stipulated in the agreement. And having gone through the recitals of Exhibit 1, it is pretty clear that the appellant had disclosed having cleared the 5 EMIs amounting to rupees so and further paying rupees 1 lakh to the finance company, which was later on rebutted by PW5, an official of the finance company, and the recitals of Exhibit 1, 2, and 3. I must also point out that appellant has nowhere during trial adduced any evidence to show that she had deposited rupees 1 lakh to the finance company. So in the agreement, she has agreed that she already paid 5 installments and she paid 1 lakh, but in fact,
PW
Lordship.
five is rebutted.
PW five rebutted that no such amount was paid by the appellant. Thus, I conclude that the appellant has failed to adduce cogent evidence to prove that the failure to pay 46 numbers of EMIs to the finance company and failure to pay rupees 1 lakh to her into installment lies upon the respondent. Rather, the overwhelming evidence on record proves that it was she who has violated the terms of the agreement, and so it is not the respondent who has violated his terms of the contract, and so the respondent was legally entitled to revoke the agreement and seek for refund of the part of the payment of rupees 4,90,000. It is true that the agreement between the parties stipulated that the remaining amount of 4 lakhs was to be paid by the respondent in 46 months EMI to the finance company, and that the respondent shall also have to repay the amount of rupees 1 lakh in 2 equal installments within 30/11/12 and 30/1/13. Failing which, the appellant shall have the right to repossess the vehicle, and the respondent shall have to forfeit the part payment of rupees so and so. And since the appellant has failed to perform her part of agreement, rather made misrepresentation in the agreement, the respondent is entitled to recover 4,90,000 from the appellant. That apart, the fact remains that nowhere in the agreement, that is Exhibit 1, it is stipulated that the amount of rupees 4,90,000 was the earnest money taken primarily as a security for the due performance of the agreement.
It's okay.
Lordship. So, Lordship, in the question, these are facts, Lordship.
Yes.
Already both the courts decided in favor of the plaintiff, Lordship. And Lordship, concurrent finding of facts, Lordship, under section 100, Lordship, there is a very limited scope to interfere, Lordship. And in this case, Lordship, they obtained a stay order from this court in IA, Lordship. And thereafter, normally money decree, Lordship, 50% of the amount has to be deposited. But that was not done at the time of admission of the appeal. So we are praying for an early hearing, Lordship.
Yes.
So my learned friend has finished, my lord.
Yes.
I also beg to draw the judgment of the criminal code, my lord. It was dismissed, my lord. They raised objection of 420 against us. It has been judgment may be considered by your lords.
All right.
My learned friend has read out the judgment. It is true and correct with the findings by the court, but question that I put, my lord, that is, they have traveled in a misguided way without filing a civil suit under Specific Relief Act. That is the Exhibit 1, my lord. And your lordship, if your lordships can see the evidence also, my lord, it is repeatedly stated a question of agreement. The agreement fails, they may get a money suit, but not in that way by filing the money suit. There should the civil procedure is there. Specific relief it has been violated.
All right.
Much obliged.
I have noted down this reply from your side.
Yes.
Let's see. Third learned counsel, Mr.
M.H. Rajbor Bhaiya.
M.S. Rajbor Bhuiya.
Yes.
For the appellant and learned counsel, Ms. R. Chaudhary, for the respondent, reserve for judgment and order.
Lordship.
Much obliged. ma'am.
Yes. I don't think I'll be able to hear any more argument today. I'm not feeling well.
This is, it's okay, but it is,
I'm not feeling well.
okay.
Backache. I won't be able to sit, I think, very long.
Can it be fixed, because it's a big.
Yes, sure.
Can it be fixed before the vacation?
Sure.
Definitely, obliged. 16 September. What's it, can it be on 16 September? 16 September?
Have to, because I'm taking adjournment.
It's nothing.
এইটো ভৰাই দিয়া জানো তেনে 16 September. Which item number? 22. 16 September লিখি দিবা হা। Due to নালাগে এইবোৰ লিখিব নালাগে, list this matter on 16 September ইমান লিখিলে হৈ যাব। Anybody, any other item? Tell me when do you want? I won't be able to hear. I'm not feeling well.
Next week, my
Tell me
lord,
when
as
do you
per
want?
lordship's convenience, my lord.
Huh?
Next week, my lord. Next week, my lord.
Next week. Next week কেতিয়া পাৰি? 18 September.
কিমান সময়?
তেনেকে ডাইৰেক্ট লিখি দিয়ে।
18 September. Much.